Thank you, ladies and gentlemen, for joining us at the Beverly Hills Bar Association's program on legal issues in the age of COVID-19. Today's program is a fascinating one on issues of healthcare law, trusts and estates, and elder law. And our presenters are John Mills, who is a partner at Nelson Hardiman LLP. He is a specialist in healthcare law. And he will be talking about telehealth, that is remote treatment options in a world where we are all observing social distancing. Zach Dresben is a partner in Dresben and Kramer. Correct me if I'm wrong about that. Is that the name of your firm, Zach? Say again?
Kramer and Dresben.
Kramer and Dresben. Well, I was trying to give you the starring role, Zach, but you're too modest for that. And he is a lawyer who specializes in trusts and estates and probate matters. And last but not least is the chair of the Beverly Hills Bar's Elder Law Committee, Terry Magedy, and he will be talking about elder law. I am Michael Sohigian. I'm the president of the Beverly Hills Bar Association, and I will try and keep out of the way now. So John, please start us off.
All right. Thank you very much, Michael. I appreciate it. Thank you to the Beverly Hills Bar Association for having me. So I'm a healthcare attorney, as Michael mentioned, and I've been pretty busy the past month and a half with as a result of this crisis. I mean, in some ways, it's almost turned into a little practice area for my firm. We're a full-service healthcare firm, so all we do is represent healthcare providers, and that is everything from hospitals to medical practices to nursing facilities and ambulance companies and drug and alcohol treatment centers, and pretty much the whole spectrum of the healthcare provider community. So we've been staying busy, getting a lot of questions, and I would say that the issue that we immediately were being asked about when the stay-at-home orders were issued and all the social distancing really became front and center in everybody's mind is about providing services via telehealth. Telehealth is something that's been around for quite some time. It's been developing for many years. But it's something that despite its widespread availability, a lot of providers have not been utilizing it. And now suddenly it felt that they really needed to. As you can imagine, people are not exactly eager to go to the doctor's office right now. People are trying to minimize their exposure, and appointments are getting canceled. Elective procedures are being canceled. In fact, they're being encouraged to be canceled. But there's still quite a bit of service that healthcare providers can deliver through a telehealth modality, meaning a video conference like we're on right now. So with that, let me just give my disclaimer. This is not meant to be legal advice. This is just for informational purposes only. Keep in mind that this is a rapidly expanding issue, right? It's on flux. I'm looking at updates from state, federal, local, and all the various payers on an almost daily basis to see like the old news tomorrow. So please keep that in mind. And also keep in mind, if anybody out there who's not in California, for my presentation at least is meant to be California-centric. I'm going to be primarily focusing on California rules. I will certainly be talking about some federal issues, but note that telehealth is something that is largely governed by state law, and that law can change from state to state. And it also can change very, very widely from one payer to the next. So when we talk about telehealth and whether to provide a service via a telephone or video format, there are certain assumptions that need to be taken into account. With most important is it appropriate to provide this service via telehealth? Which the doctor or the other healthcare provider's ability to provide the service has to be, and medical appropriateness. It's within the judgment of the healthcare provider to decide whether it's safe and effective, but ultimately they are still going to be held to the same standard of care guidelines and rules and laws that would apply as if the delivery was in person. A second assumption is that the communication that's going to be made is going to be secure and effective. Well, I'll spend more time on HIPAA in a few minutes, but you cannot do telehealth via Facebook Live, for example. It's got to be a secure connection. Number three, another assumption is there has to be a need for delivering the service via telehealth. It can never be for really just the convenience of the patient or the convenience of the provider. So even right now, when there's all of this social distancing going on, you have to keep in mind that healthcare workers are essential workers. They are not subject to stay-at-home orders, and there is no requirement that people not go to the doctor's office right now, or that there's no requirement that doctors not see patients in person right now. It's just more of an issue that patients don't want to see doctors right now in person. They don't want to be in a doctor's office. There's just an effort to have the social distancing, to be the need to give a particular service via telehealth. It can't solely be for anybody's convenience. Fourth, actually, let me jump to 5 real quick, and this relates actually back to number 2. There should be mechanisms for clients to give feedback to the provider to address any issues and satisfaction with using a telehealth service. So, clearly with telehealth, there's a risk of connectivity issues. There's the risk of privacy issues. There's questions of whether really the provision of care is going to be informative and educational and effective. And the patient needs to participate in that process. So we always assume that the patient has the opportunity to provide feedback on whether or not it was an effective format for getting care. And then lastly, I wanted to say that as another basic assumption is that if the telehealth service requires an authorization, then an authorization from a payer, meaning an insurance company or a government program, then somebody needs to find out first, do I need an authorization here? Because if there's any request for reimbursement for that service, then don't proceed with the telehealth encounter if that authorization hasn't been granted. But keep in mind that it's not universally required to have authorizations, but it's always advisable to at least find that out first. All right. The issue of licensure is a fairly threshold issue when providing telehealth. It doesn't become much of an issue if the provider and the patient are both located in the same state. Generally speaking, a licensed California doctor is going to be able to provide telehealth services to a patient located in California. But one of the barriers to telehealth is that precisely what it's useful for, which is communicating over obviously large distances. There's still a limitation on the ability of a provider to provide services to a patient located in another jurisdiction if that provider is not licensed in that jurisdiction, which is very often the case. So that is a barrier. If the doctor is located in California and the patient's located in Arkansas, then the doctor is going to need to check with Arkansas law to see whether Arkansas requires that doctor to be licensed in Arkansas in order to provide telehealth services to a patient located in Arkansas. And I'm throwing Arkansas out because generally I actually haven't checked the law of Arkansas, so I don't know whether Arkansas in fact requires a licensure for a telehealth encounter. But the point is, you have to look first. And there's been an overall trend over the years to go towards a certification process, so that doctors who are licensed in one state can get certification to provide telehealth in another state. But that's not universally accepted, and we're not at that point yet. So just keep that in mind. All that being said, crisis, we are seeing a significant relaxation in the area of these licensure requirements. For example, the Centers for Medicaid and Medicare Services, CMS, has suspended the requirement that the provider be licensed in the same state as where the Medicare beneficiary is located. Medicare reimbursement, however, that Medicare doesn't suspend state law licensure requirements. So even though you might still be able to get paid by Medicare, you still need to check that the law of the state where the patient is located, because if you're not licensed in that state and the state requires licensure, then Medicare may not have an issue with it, but you're going to be violating that state's laws. So just keep that in mind. Informed consent is another issue. Whenever any provider to any medical service being provided, there has to be informed consent by the patient. But in telehealth, there's actually a specific requirement in the Business and Professions Code for obtaining specific consent to telehealth. And I've pretty much quoted the statute here. It says, before the delivery of healthcare via telehealth, the healthcare provider initiating the use of telehealth shall inform the patient about the use of telehealth and obtain verbal consent from the patient for the use of telehealth as an acceptable mode of delivering healthcare service. The consent, meaning it should be documented in the patient's medical chart. So this is an important requirement. This is standard. This is the law, and we always advise our clients to make sure they're getting that specific consent to participate in a telehealth encounter. However, that being said, right now with the COVID crisis, the governor used order, I want to say about 2 weeks ago, suspending this specific requirement, as well as suspending some other privacy laws, which I'll talk about in a minute. But there was a suspension of a lot of things that can easily get providers tripped up if they're new to telehealth. So for now, this consent requirement is not there, but we advise our clients that, notwithstanding that it's currently suspended, it's still best practice. It's still a good idea to go ahead and move forward with getting that consent. There's a lot of different reasons why you want to make sure you're getting consent, including just making sure that the patient understands the limitations of receiving services via telehealth versus in person. And the insurance company that the claim might be submitted to, it might have its own consent requirements, so you need to keep that in mind. So we just tell our clients, go ahead and move forward with getting the consent. But just, it's interesting to know that right now, the governor issued an executive order saying you don't have to get that consent. Privacy and security. So I'm sure most people attending this have heard of the HIPAA law. That's a federal law that governs patient privacy, that provides protections for what's known as protected health information. It's a very complex law that I'm not going to get into right now because I simply don't have the time. But I do want to point out that under normal circumstances, the HIPAA rules require specific security safeguards for electronic protected health information at rest and in transit. So this requirement would exclude the use of many virtual conferencing platforms used widely nowadays for non-medical purposes, including Zoom and Skype. Now, there are certain types of Zoom, like there are certain types of business Zoom and business Skype, that would be okay under the normal HIPAA rules. But there's a lot of telehealth platforms out there, platforms that are very specific to telehealth. So medical providers who have already been using telehealth are probably already set up with one of those platforms. But right now, with so many health providers having to jump into providing telehealth on the fly, the Office of Civil Rights, it's a federal agency that enforces HIPAA, it has said that it will not impose penalties during this public health emergency for non-compliance with these rules, so long as the telehealth service is being provided in good faith and with a non-public facing remote communication product. So Zoom, Skype, Apple FaceTime, that would all be fine. Things like TikTok or Facebook Live, it would not be acceptable, obviously. And
John, this is Mike Sohigian. Are there
yes, Mike.
Are there specific healthcare specific providers of telehealth services that are HIPAA compliant, who've been in this space for a while before this crisis?
Yes, there are. There are telehealth vendors. Teladoc is one of the big ones. Most of the insurance companies work with and are contracted with a telehealth vendor. So no, there's plenty of them out there right now already. That's actually an interesting issue, because initially when this crisis was unfolding, a lot of the insurance companies were saying, well, we're only going to cover telehealth service if you're using our telehealth vendor. And I'll probably touch on it in a few minutes. California, at least, the Department of Managed Healthcare as well as the Department of Insurance have both said, no, not right now. Cannot require, you're going to pay for any telehealth service. You're not only going to pay for what your contracted telehealth vendors provide.
Thanks, John.
Yeah. And just lastly, on the privacy and security piece, just be aware that Governor Newsom, the same time he suspended that informed consent requirement, he also relaxed certain privacy and security laws. California has its own version of HIPAA, so to speak. It's called the California Medical Information Act, Civil Code Section 56.10, which has all sorts of penalties and private rights of action for privacy violations. And that's been relaxed. A lot of the penalties are being waived for telehealth services being provided right now during this crisis. So let me talk real quickly about reimbursement. And that's actually an issue that I get questions on from my clients all the time, because they want to make sure they're going to get paid for doing telehealth. The law in California right now, under Health and Safety Code Section 1374.14 and Insurance Code Section 10123.85, the law is that effective January 2021, health plan and provider contracts must specify that the plans will reimburse providers for telehealth on the same basis and to the same extent as in-person encounters. So that means there's going to be parity in the reimbursement of telehealth. If the service can be delivered via telehealth, meaning it's within the standard of care, then it's got to get paid at the same rate as that service would have been paid in an in-person encounter. So that's the law, but that law is not on the books effective until next year. What's happened right now, because of this crisis and because of this rapid shift in the use of telehealth, the Department of Managed Healthcare, which regulates HMOs and certain health plans, and then the California Department of Insurance, which regulates insured health insurers, insurance products, they're requiring all of these payers to essentially meet these parity requirements during the COVID-19 crisis. There's some distinctions. They're not exactly requiring every element of the laws, but it's pretty darn close. So, and I'm happy to talk to anybody afterwards about any specific questions on this, but it's essentially we've achieved parity about 1 year early as a result of this crisis.
And that's to incentivize people to use telehealth where it's appropriate, I imagine, huh, John?
That's to incentivize the use of telehealth, and yes. It's also to incentivize the use of telehealth, and it's also intended to make sure that when telehealth is being provided, because putting aside that right now that we have a crisis, there's plenty of times when there's a need for telehealth. There's plenty of times when it makes more sense for an encounter to occur via telehealth than it would via in person, and we don't want the payers to somehow take advantage of that need by paying less. So yes, it all boils down to incentives, but it's also to achieve really just fairness to providers as well as patients. So that's all I'm going to say for now about reimbursement. I guess I should mention also that there's been a lot of changes with Medicare right now, with Medi-Cal, even purely telephonic visits are okay with Medi-Cal. Just recognizing that a lot of people who are on Medi-Cal and depend on Medi-Cal probably don't have or may not have access to Zoom or know how to use Zoom. So same thing with a lot of elderly people on Medicare. They may not know how to use Zoom. So telephone is fine right now. We'll see whether that sticks. So that gets me to my last slide, my takeaways. We're experiencing all of these fast changes in telehealth. And there's already been some talk saying, hey, you know what, this is actually working pretty well. People like the use of telehealth. So there's already serious discussion at the highest levels, including at the CMS administrator, saying they're going to look into expanding telehealth permanently, even after this crisis ends. The other takeaway is when it comes to reimbursement, there's Medicare, there's Medicaid, and then you've got all these other programs, and you've got all these individual payers out there. They have their own guidelines. Private commercial plans, while they're going to be subject to things like the Department of Managed Healthcare, say, and Department of Insurance, they're still going to have their own requirements and guidelines that they can impose. And so I always advise my clients, the provider community, to make sure they're educating themselves on what those guidelines are. Anthem might have slightly different guidelines than Aetna, for example. So it's very important to be educated and to communicate with the insurance companies about what their telehealth guidelines are. One of the things that we're expecting to see is, there's unfortunately in healthcare, there's a lot of fraud in healthcare. It's very ripe for fraud, and with this heavy relaxation of a lot of rules right now, we do anticipate that there's going to be people taking advantage of that, and unfortunately, and abusing it. And so we do expect to see that down the road, a lot of the insurance companies, Medicare, et cetera, are going to be doing careful audits of all the claims, all the telehealth claims they're receiving right now, and are probably going to be asserting overpayments and potentially asserting fraudulent claims. So it's something just to be, that's something we see on the horizon. And then just, obviously, technology, does it cost jobs? It might. I mean, we've already seen certain providers where therapists are usually doing things in person. And therapy is one of those things, like this would be like a behavioral therapy. Therapy is one of the things that lends itself very, very well to telehealth. You don't need to have a doctor laying hands on the patient for that. And we're already seeing a lot of therapists out of a job right now because their employers have said, you know what, we're just going to switch over to telehealth. We don't need as many people going out to the person's site, to their home and providing therapy. We're just going to have a handful of people. They're just going to do it from home. So we don't need as many people. So we've already seen that happen. But on the flip side of that, there's sort of like, is there going to be more provider productivity if people aren't traveling as much? If either patients and providers not traveling as much, are we going to overall see more healthcare being delivered at a faster rate? So that's more of a question. Not entirely sure how it's going to play out, but those are all things that are interesting to me and to my colleagues and to my clients, and I hope it's been interesting to you as well. Thank you very, very much.
Thank you, John. And now, Zach, why don't you tell us a little bit about the estate planning issues of the COVID-19 crisis?
Hi, my name is Zachary Dresben, and I am a certified specialist in estate planning, trust, and probate law. As you can see, I'm socially responsible attorney, and I'm conforming to social distancing practices with my co-presenters. I would like to thank Linda Chung and the Beverly Hills Bar Association for inviting me to present to you today. By contrast to all my prior speaking engagements, it's a little challenging to read this room, but it's also very nice not to have my pants on. I'm just kidding. My firm, Kramer Dresben, not Dresben and Kramer, is a boutique trust and estates practice across the street from the LA County Museum of Art and La Brea Tar Pits in Miracle Mile, focusing on estate and tax planning, trust administration, and probate. And the past 5 weeks have been a very interesting time for my practice. The probate courts in LA and surrounding counties are effectively closed until the end of June, which has shifted my work away from court supervised administrations to more estate planning and trust administrations. As the current president of the Los Angeles Estate Planning Council, and being in touch with many of my other friends and colleagues in other trust and estates offices, I would like to spend the next 10 or 15 minutes to discuss issues estate planning attorneys are confronting during the ongoing pandemic, and conclude with some strategic estate planning opportunities given what we expect to be a very volatile market for the foreseeable future. I was with my study group on the evening of March 11th when President Trump announced travel restrictions on 26 European countries in a bid to combat the spread of the coronavirus. The same day marked the end of the longest bull market run in history. The World Health Organization declared the coronavirus a pandemic. The National Basketball Association abruptly suspended season after a player on the Utah Jazz tested positive for coronavirus. And of course, who would forget, Tom Hanks and his wife, Rita Wilson, announced from Australia that they had tested positive. That evening and the following day, I began to drastically revise our office's business logistics and develop new protocols for my representation of estate planning clients. By the end of the week, my associates and I were more or less prepared to work from home for the foreseeable future. Knowing that I would no longer be meeting with my clients in person anytime in the near future, my office underwent several significant changes and developed and adopted new methods for what I now believe is required for the modern law practice, including the use of Zoom for most otherwise in-person meetings, heavily encouraging clients to remit payment electronically, including ACH and wire transfers and PayPal, and using DocuSign, or my office uses Adobe Sign for electronic signatures for simple agreements like engagement agreements, and run as much of a paperless practice as possible. As a 36-year-old attorney, I'm embarrassed to admit that engagement agreements, letters to clients, drafts of estate planning documents for client review, bills, all previously were sent via USPS, and virtually every written communication is transmitted by email and PDF attachments now. We had to modify a significant portion of our form library accordingly, which included a new agreement our clients would electronically sign should they wish to execute their estate planning documents remotely. I will talk about the need for this agreement in just a minute. So to briefly review, advanced healthcare directives and durable powers of attorney can either be notarized or signed by two disinterested witnesses. I know some offices are working with their clients to facilitate the execution of holographic wills when witnesses or a notary public cannot be arranged, or if you have a client who's contracted coronavirus and no one is willing to be with them in person. I encourage you to be very, very careful instructing your clients through executing a holographic will, as my confidence with clients following specific instructions is not exactly highly optimistic, but maybe that's just my clientele. In front of you are two holographic instruments that my office has probated in previous years. They're a matter of public record, and you can imagine the look on the clerk of the probate department when he saw the underlined fragment of this will. The rules for holographic wills can be found in Probate Code section 6100 and subsequent. In light of Probate Code 6111, you can draft certain provisions of a will if the signature and the material provisions are in the handwriting of the testator. A trust agreement is valid if your client has signed without notarization. The challenge is funding the trust, as the legal department of most banks will not accept an unnotarized trust. Unfortunately, I'm of the opinion that the signing of estate planning documents is inconsistent with social distancing practices promoted by the Center for Disease Control and other governmental agencies and healthcare providers, unless clients have living room tables like Logan Roy. I believe all witnesses should be in the same room. Witness video conferencing or witnessing through windows seriously undermines the validity of the will. I know the Trust and Estates section of the State Bar of California is working to obtain an executive order or legislation in which California notaries can perform notarial acts by video conferencing during California's declared COVID-19 state of emergency, subject to certain requirements. I don't think it's going anywhere, and I'm not sure I'm an advocate of the proposal, but I wanted to make you aware of that. I want to give you some context for the nature of the agreement that I have my clients sign. As the vast majority of our clients live within 10 miles of our office, clients always signed their documents at our office, which ensured their validity and subsequent safekeeping. Should the estate plan ever be litigated posthumously, I could always testify who was present during the signing and under what circumstances. Our office permitted the remote execution of estate planning documents without attorney supervision in only the most limited of circumstances, mostly for clients living in other counties. In my experience, these remote executions never went well, and I was always dumbfounded to see clients not signing on the signature line that was uniquely tabbed, but rather in very creative places, or to request material revisions moments before or during the signing, as they later acknowledged not reviewing the draft documents mailed to them on a prior occasion. Around this time, as I'm sure many of you experienced, there was panic, and I mean panic, by many new and pre-existing clients wanting to create or amend their estate plans, and they all wanted to sign like yesterday. I had one client, and I kid you not, whose drafts were sent to them for their review over 3 years ago, and they sent me an email with one minor revision and were ready to sign. The purpose of the new agreement that new and pre-existing clients have to sign prior to me sending execution copies of their estate planning documents for their signature is not only to ensure the validity of the documents, but to eliminate or at least mitigate any possible undue influence, ensure testamentary wishes are not the byproduct of panic or lack of thoughtfulness, and to explain the nuances of the signing ritual, including the need for a notary public or disinterested witnesses. I had one client unable to obtain a second disinterested witness, and she took my advice of engaging 2 traveling notaries to visit her at her home. It must have been a disappointment for the second notary to see the first collect the additional signatures. Without the lease to Xerox that can print out what I believe is 200 pages per minute, our office will transmit execution copies via PDF to our clients if they agree to the following. As we do not want to send undated execution copies that could be signed either next week or next year, we require the name of the notary public exactly as reflected on his or her notarial seal, who will be notarizing the documents and the date of execution. Clients agree to acknowledge that they have reviewed the drafts of their estate planning documents for the accuracy of all material provisions of their estate plan, including, but not limited to, the named fiduciaries, healthcare agents, beneficiaries, including the spelling of all names, dates of birth, phone numbers, and other information. Clients need to confirm that they are able to print the estate planning documents, which average over 150 pages, on single-sided standard quality office paper, as these documents need to be preserved well after their passing. Further, that they will have 2 disinterested witnesses available and agree to transmit the original copies of their estate planning documents to our office within 48 hours of execution, so that I can review and ensure their validity. Mindful of elderly or computer illiterate clients, any clients desirous of receiving hard copies mailed to their home simply need to provide me with additional advance notice. When I transmit execution copies, I also transmit a separate standalone document with a description of all of the documents that need to be signed, indicating in what order the documents are signed, who signs what documents on what pages, which documents need to be signed, which need to be notarized and where, and which documents require the signature of 2 disinterested witnesses and on what pages. Obviously, when I send hard copies, I include signing tabs, as it's difficult to do the same when sending PDFs. Upon reviewing the execution copies mailed from the client to me, which I handle with latex gloves, it would still be impossible to ensure that the trust was signed before the wills had my clients not thoroughly reviewed the execution rituals and signed the agreement. Some other considerations that other offices have implemented that I have adopted are the use of video conference to observe the signing ritual and to place restrictions on the location of signings. If clients need to go to a bank or other location where the notary works, this could complicate the no one else was present conversation during the signing. I'd like to conclude with some strategic estate planning opportunities given the volatile markets and the historically low interest rates. It's a great time for your wealthier clients to consider making gifts to GRATs or grantor retained annuity trusts. GRATs funded now will only need to outperform the 0.8%, which is the current 75/20 rate, in order for the trust corpus to pass estate tax-free to remainder beneficiaries at the end of the GRAT's term. As the tax code requires the loans be made with a minimum amount of interest, clients should consider making a low interest rate loan to a child or grandchild, refinancing an existing loan to reduce the rate, or lending to a family member or grantor trust for the family member who invests the proceeds in fixed income or other investments. A grantor can also swap assets of equal value of an irrevocable grantor trust if they have the power to do so, or sell assets to a trust in exchange for a low rate promissory note. As a result of the stock market's correction, certain clients can consider converting traditional IRAs to Roth IRAs because the account owner will have taxable income on the value of the traditional IRA's assets on the date of the conversion, post-correction. I really appreciate your time today. I want to thank all of you in the Beverly Hills Bar Association for this opportunity to present to you today. Once again, I'm Zachary Dresben of Kramer and Dresben, and if you have any questions about any matter whatsoever, estate planning wise, or anything that this presentation touched upon, please don't hesitate to contact me at the information on your screen. I hope you're all safe and healthy, and I look forward to hearing what Terry Magedy has to say. Thanks, Michael.
Thanks, Zach.
You're welcome. Thank you, Zachary. Yeah, and now, as I said, last but not least, let's hear from Terry Magedy regarding elder law issues.
Okay, so in the short time that I have, I want to focus on government benefits, especially Medi-Cal, and it's for this reason. From my own special vantage point, I'm already seeing a third and a fourth tsunami around the corner. And it's not one, it's not death rates from COVID-19, and it's not two, the economic pain of COVID-19 shutdowns, rather three, the increased illness that's either coming from the aftermath of COVID-19 or from other diseases that are being ignored as a result of COVID-19, and then consequently, four, the higher demand for long-term care. And to give you one example, ventilators have been a savior, and now they're part of everybody's vernacular now. You know, everybody knows what a ventilator is. For me, in my practice for the past 25 years, I've been very familiar with ventilators, but not from the medical perspective, really from the financial perspective, because up after 100 days, and usually it's before 100 days, Medicare and private insurance stop paying for subacute care, which includes ventilators. And so then the families just have two choices. Either they pay, but that's to the tune of about $25,000 a month, or they get on Medi-Cal. So Medi-Cal eligibility and asset protection becomes critical. And from my perspective, at least, for this period of time, a deliberate and a thoughtful approach to Medi-Cal long-term eligibility is very important. And because there's so much confusion among attorneys, CPAs, actually just everybody about the Medi-Cal program, I want to share three principles to keep in mind. And then after I share the principles, I'm going to talk specifically about COVID-19 related programs and Medi-Cal. Principle one, there are different types of Medi-Cal programs, and each of them have their own rules for eligibility and allow opportunities for planning, because so many types of assets in the programs are either not counted or are counted in very unusual ways. So consequently, many families can become eligible for Medi-Cal with relatively simple tweaking of assets and income in the right direction. And just to give you an example of a short list, so you get a sense of this, exempt or not counted assets: a home, even if it's an apartment building, other real estate, with encumbrances. They're in excess of property tax assessed values, certain other real estate when you're trying to sell it, and certain real estate that you own, or other property too, that you own with someone else. Your own IRA, if any distributions are elected, your spouse's IRA, even if no distributions are elected, many trusts, as long as they're from third parties, they're not your spouse, and many types of gifts. And that's a short list. Principle number 2, the expanded Medi-Cal program that came with Obamacare does not even count assets at all, and opened up eligibility for people under 65 who don't have other insurance and who just structure their income properly. And finally, principle 3, that starting in 2017, Medi-Cal recovery became so limited that just basic estate planning knocks out almost all state recovery and makes it unnecessary, and it's sometimes even harmful, to gift certain assets like a home. So now, knowing those 3 principles, let's go to some COVID-19 special issues and see the interplay with Medi-Cal. When you think of this, remember that it's not only a Medi-Cal recipient. Medi-Cal recipients, or people who are older or disabled, have spouses, have family members, and it's usually that the spouses or family members are trying to help the disabled individual. So you really have to look at them as a whole. Let's start with the additional $600 a week that somebody gets for an unemployment benefit, which sounds good. But yet, on one hand, if the disabled spouse is on the expanded Medi-Cal program with Obamacare, that extra income is counted and can throw the family off Medi-Cal. On the other hand, if you have a disabled spouse that has historically been the small breadwinner in the family and is on a more traditional Medi-Cal program, or what they call spousal impoverishment rules have already been applied to the family, then that extra money is great. Not even in the picture really for accountability for assets. But in any event, the unexpected money, very similar to personal injury settlements, inheritances, has to be considered by the family about what you do with it and how can it be sheltered for Medi-Cal if that's something a family wants. Second, the $1,200 stimulus check. Now that's a benefit, at least the CARE Act specifically addressed regarding public benefits. The CARE Act says it's not counted as income, and the CARE Act says it is not counted as an asset for 1 year. So that means if someone wants to keep it as a rainy day fund, it should be set aside in a very similar fashion that we do with other assets like that, like Nazi war reparations, Japanese internment reparations, where you set them aside so you know those are exempt, that's exempt cash that's sitting there. But thought has to be given also to what happens when the year expires. Do you turn this exempt asset into another exempt asset? Or do you make a non-disqualifying gift while it is an exempt asset? And then there's a special problem with the $1,200 stimulus check. And that's many families, almost without thinking, put a disabled family member down as a dependent. So that makes them ineligible for the $1,200 that they would get. And so then people who, even though there's an April 15 deadline that was extended to July 15, some families may want to get their tax returns filed for 2019 so they can not put down a disabled family member as a dependent. Third program, the PPP, Payment Protection Program. It's in the news constantly. Anybody in business has heard of it. It has very nice elements for Medi-Cal planning in that the money is borrowed. So it works like a loan, like a reverse mortgage where you borrow the money. It's not counted as income for public benefits. But once it hits, it could be an asset, depending on with it, how fast you do something with it, which Medi-Cal program someone's on. Next, the 2020 IRA RMD deferral, the required minimum distributions that people are supposed to take now it's changed to age 72 when you have to take it. that presents a medical planning opportunity to make your own IRA not counted just by taking a tiny distribution. Let's say just $25 a year. That makes it called unavailable for Medi-Cal purposes, instead of the income for RMD, which presents problems because it increases income coming in and increases someone's Medi-Cal share of cost. So now an older person, say someone over 72, with normally you have to take the RMD, can choose to make a IRA unavailable with this minuscule distribution. This is the same strategy that's used for people who are younger, even under, in their 50s or in accidents or something, they have IRAs, by taking just a small distribution instead of something big. So you make the asset not available and you don't have any income to speak of. So it doesn't add to your share of cost. Tenant protections. Now, older people, like everyone, likes when people pay rent, if you have rentals. But you have to keep in mind that when a tenant stops paying, that could be, maybe it's your apartment building that you have, your second home that you have, or these days, what you considered your very safe triple net top line restaurant franchise lease stops paying income. That also is you want the income, but on the other hand, you can use the lack of income to decrease a Medi-Cal share of cost if someone's on, or if someone in the family's on Medi-Cal. Lender protections. Now, if you're going to get a forbearance, you should consider.
Terry, can I ask you a question? We've got a question from Noreen. She asked whether Social Security payment disqualifies the recipient from Medi-Cal eligibility. So this is an 87-year-old receiving $2,000 a month.
Oh, 2,000. It depends on they're a couple or an individual. Should we say an individual?
I believe it's an individual according to this question.
Yeah. Individual. It certainly the income doesn't disqualify you, but it may affect your share of cost. So typically, the issue that comes up with just an individual who has $2,000 a month Social Security, they have to do something related to planning, and the options are very limited, but you can do a few things to try to reduce your countable income down to about $1,200 or $1,300. So you're on Medi-Cal, but you're just going to have, without any thinking about it, you're going to have a high Medi-Cal share of cost.
Okay. Thank you, Jerry.
Like a deductible.
Sorry to interrupt.
Okay. That's okay. So lender protections, think about what asset you want to get your forbearance on. If you get a forbearance on your home loan that you live in, that may be fine if you don't have any income coming in from the loan. Great. On the other hand, if you're looking at forbearances for your second home that you have rental income coming in, that installment payments you're paying may have been reducing your Medi-Cal share of cost, and you may not want a forbearance on that particular property. So it's something just to think about. And next, we have what I have not seen yet, but I'm anticipating it'll be a brand new issue of COVID-19 related unavailability for real estate. Now, usually in the past, I've used this just in unusual circumstances. We've had like a shopping center, but there was litigation, so it was unavailable. It wasn't counted. It couldn't be liquidated. But now with an apartment building, really depending in some ways on the goodwill of tenants to offer their rent check, or a home you're trying to sell, another home that has a tenant in it, and all of a sudden you can't show it really in person. I'm anticipating we may have other arguments about assets being unavailable and not counted for Medi-Cal purposes. And finally, the very special Medi-Cal issue with what's called in-home supportive services. It's a Medi-Cal program for care at home, acronyms IHSS. There's a special issue that's coming about now in that when people are out of necessity, they're living together. So you've got a caregiver and provider who maybe before were living separately, but now, and you're usually talking about a family member, out of necessity, they're now under one roof. The family has an opportunity to make use of a IHSS, in-home supportive services, federal and state tax exclusion to get the caregiver, that's usually a family member here, free money, not only free money, but free money that is tax-free because they're living together. They're the caregiver and the care recipient. That's a nice bonus. Now, when we're talking about fiduciaries in this discussion of government benefits too, I know a lot of people represent fiduciaries. I represent many fiduciaries who have beneficiaries who are older and disabled. They're going through all sorts of things via Zoom and other issues the care providers are going through that John mentioned earlier with respect to telehealth or maybe telemonitoring of their beneficiaries and the care the beneficiary is getting, special new protocols, specialized monitoring. But I believe the fiduciary also has a duty now to at least examine the government programs for the beneficiary, at least look at it because, you know, there may be potential money to be had for your beneficiary. And finally, it wasn't my focus because I thought everything was government benefits, but I just want to make a note on family disputes, which are usually that takes up a major part of an elder law practice when people are fighting about an older person or disabled loved one. But for me personally, I believe the chess pieces have actually changed that give us really a mandate to try to think more creatively about the disputes. And that's particularly because, as we saw earlier in the presentation, the courts have become much more challenging as an avenue to get into as a way of protection or a way to take some kind of action regarding the older disabled person. So maybe that resort to more creative means of dealing with the disputes, maybe it's going to be a blessing in disguise even. So we shall see. Thank you.
Terry, thanks a lot. So what are you talking about then? Are you talking about some kind of a neutral mediation, some alternative dispute resolution?
No, I mean, I was not really thinking about that. I mean, just for me, when someone comes in, usually there's an issue with a family member. There are other ways to try to get the job done or to either protect the family member. And you're always thinking about those, or you should anyway, instead of just running to court or running to do some more aggressive action. But now I think you have a even greater mandate to do that because one, very hard to get to court. Two, and even operate in court the way you would normally do in person. You know, so many personal dynamics are happening there in the probate court that aren't quite the same when you're trying to do it just via court call. So you're trying to think creatively about the problem. How could it be solved? How could you take an action in some other backdoor angle to get what you really want to happen? And I'm not necessarily talking about mediation, although I guess that's always, a fine thing to consider. I'm thinking of other steps before court.
Terry, we got some feedback on the chat about your presentation. You didn't have any slides, but I understand that you have an outline that will be part of the materials that will be provided to the attendees with their MCLE certificate by email tomorrow. So there it is. There you go. So look forward to receiving that. And also, of course, you can always reach out to Terry if you have any questions about his presentation. I'm sure he'd be glad to talk with you. Zach, does your firm do probate litigation?
We are litigation light.
Litigation light, okay. So in terms of the questions that Terry raised about judicial responses to the problems that his clients, and I imagine your clients too, will face, do you have any input about that? Do you have any insights to what the probate courts are likely to look like after the courts reopen sometime in the end of June, I guess?
Well, all of our matters that have been heard or would have been heard in April have been rescheduled to June, July, and August. So I don't anticipate anything other than a lot of continuances and further congestion in the court system.
Of course, it sounds like there's a difference between Terry's practice and your practice in that, as they always say about the probate practice, we got all the time in the world because everybody's already dead, right? Whereas
Yes.
Terry's clients are living, albeit under some extreme circumstances and maybe with a kind of a short time frame to respond to their problems.
Yeah, I will share, Michael, I'm going to mention one thing. I think one factor is whenever someone's weighing something, not in a neutral mode, but you're either on one side of the dispute or another regarding a family, you're always thinking, is this person going to pull the trigger and go to court? And you look at from their perspective, well, they're weighing this and they're weighing that. Now, if you look at the other side's perspective or even your own perspective, you're going to have a lot of weight on that scale with the fact that it's hard to make it happen in court. So it may change the dynamics, it may change leverage for one person or another because of knowing that the other side is going to have potential challenges, or you will have potential challenges quickly and effectively.
I agree with that comment. And I think that there's no incentive to mediate any matters at present, even if we were able to teleconference.
Yeah, that's true. We litigators like to think that, trial is the ultimate hammer. And I think that's the way the judges view it too. Mediation only works if you've got people who want to settle for their own reason or reasons. John, I want to ask you a question. Your presentation suggests that the forces that pre-existed or predated our crisis were moving us to telehealth because it was less expensive, more convenient, maybe more flexible. And it sounds like your view is that COVID-19 is sort of hastening that process. It's adding weight to that process. Yeah.
Yes, absolutely. That's what we're seeing, because I think what's happened is that healthcare providers have had to get into telehealth when, perhaps they knew about it, but they never used it. And now they're using it. And they're finding that the ones when they're able to, we have to be clear. Telehealth is not right for every type of service, right? If a doctor needs to lay hands on a patient, your telehealth is not going to work. You're not going to be able to do telehealth lab work. Somebody's going to have to come in and draw that blood, at least for now. You might get to technology down the road where that's not, you don't need a person there. But we represent a lot of clients in the behavioral health space, and behavioral health lends itself pretty well to telehealth. And it's amazing how many providers had never used it before. In fact, my wife is a psychiatrist. She had never used telehealth before, and now that's all she's doing right now. She's been doing that for the past month, and it's working pretty well for her. She's doing it from home. She has to take certain precautions to make sure the kids don't bust into the room when she's talking with the client, but it's working pretty well. So, and she works with UCLA. In UCLA, it is an outpatient clinic, and they just said all psychiatrists, therapists just work from home unless there's a need, unless the specific patient, it would be a danger. It would create more harm than good to see this patient via video, because sometimes you've got a patient volatile situation, a mental health a patient volatile situation, suddenly you can't gauge them appropriately over video, and they might harm themselves, just based on how that therapy or that encounter is going could lead to harm. In person at the medical center, they got the ability to put that person on a hold, 5150 hold, like right away if need be. Not through telehealth, right? Can't do it. Right. So that decision has to be made. But the point being is, by and large, it's working pretty well for most patients. And so I wouldn't be surprised if my wife ends up doing a lot more telehealth even after this crisis is over.
Yeah, and that's the question. It's unfair to ask you to predict the future. But but it's hard really to identify any concerns that would slow down the process once it started and gotten speeded up by the crisis that we're in, except I guess for the concerns about fraud and abuse that you mentioned in your presentation, right? I mean, it's really going to be the payors who put the brakes on it, if at all, right? And I think they probably view it pretty favorably right now.
I think so. I think you're looking at it pretty favorably. Medicare has been, which is by the largest payer out there, has been very, very slow historically on telehealth. They would allow it only in very specific circumstances, largely rural circumstances, and now they're already talking about expanding, keeping these current expansions that they've laid out very, very quickly, keeping those in place permanently. We'll see if they do, and I don't have a crystal ball, but that discussion is already underway.
Well, that's fascinating. Thank you so much, John and Zach
Thank
and
you.
Terry. This has really been a very valuable way to spend the last hour. I hope that the rest of the people who are watching and listening to us feel the same way. I thank you all again for being here, and to all of our attendees, look for your email tomorrow with your MCLE certificate and all the materials from the presentations that we had today. Please consider, if you're not already a member of the Beverly Hills Bar Association, this is the kind of education that we provide on a daily basis. We have really the finest experts in the field who are among our members, and who, even if they're not members, are glad to address an audience of Beverly Hills Bar Association members and friends. And I encourage you to continue seeking out these kinds of benefits, and to consider joining or renewing your membership to the Beverly Hills Bar Association. Thanks very much. Please stay healthy and be safe. And until we meet again, so long.
Thank you.
Thank you, everyone.